Chula Vista Rent Control. My name is Larry. I've done property management in Chula Vista for over 20 years. I'm going to be sharing with you some information and thoughts about Chula Vista Rent Control. And if you find them to be interesting or useful, I would appreciate a like or subscribe. I am not an attorney, and I am not giving professional legal advice. In fact, the information I am discussing is based on the situation as it exists today. Things can change. We are discussing Chula Vista Rent Control as legal non-professionals confronted with the challenge of Chula Vista's rent control ordinance. Rent control is intended to keep living costs affordable for lower income residents. Typically, it is a government program that places a limit on the amount that a landlord can demand for leasing a home or renewing a lease. But it doesn't have to be just that. In the case of Chula Vista, it includes being very concerned about just cause. Under the new ordinance, landlords must have a just cause reason to terminate any tenancy. This includes reasons such as failure to pay rent, violation of lease terms, or engaging in illegal activities. But you and I know that in the real world, you can have people who do bad things, and you just can't prove it. Or they're just terrible people to deal with, and you don't want them in your life. Government in Chula Vista doesn't care about that. That's your problem, maybe forever. However, if you are fortunate and can get rid of them, you may look forward to paying for relocation assistance. That, depending on circumstances, can range between 2 to 3 months of rent, quite a few thousands of dollars. Maybe you're thinking, hey, if I get a bad apple, I can just give them notice on the basis of me moving back in. Wink. Well, I would go light on the wink. We've read that if the property goes back on the market within 2 years, the landlord is liable to pay up to 6 months of rent to the tenant. That's obviously not a very good way to go. There does seem to be another somewhat more promising avenue: renovations. That can work. However, the renovations have to be substantial. And in this case, a substantial remodel means improvement to a residential unit that is one, structural, electrical, plumbing, or mechanical system that is being replaced or substantially modified, and the cost of the improvement is equal to or greater than $40 per square foot of the residential unit, and a permit is required from a federal agency, or the abatement of hazardous materials, and cannot be reasonably accomplished in a safe manner with the tenant in place, and it is necessary for the residential rental unit to be vacant for more than 60 days in order to complete their improvements. Enforcement. I don't like this ordinance, but I wouldn't play with it. As we understand it, the city attorney's enforcement powers include civil penalties not to exceed $5,000 per day, apparently with no warning or notice to cure required beforehand, injunctive relief, and in some cases a fine of not more than $1,000, or imprisonment of a period of time not more than 6 months, and private remedies that can range from $2,000 to $5,000 per violation per day. All in all, to us, this argues for the value of a property manager who understands the laws, what maneuvering room there is within this law, and knows the properties and property owners who are excluded from it. And though we don't push it, if you decide that being a landlord is no longer right for you, please give me a call and we can talk about getting the best price for you in the sale of your rental unit. I specialize in the purchase and sale of investment properties, and that's all the more pertinent nowadays. This was not a pleasant topic. However, if you would like to discuss it further or talk about any other San Diego real estate issue, please feel free to give me a call at the phone number on the screen.